Welcome back with Giulia Crescini, Avvocato Giulia Crescini, in this new episode of the Citizenship series, Italian Citizenship series. Very fast introduction. I am Davide Di Monaco, the founder of MultiLex, and we are a services agency, and we help Italian foreign citizens deal with Italian bureaucracy, and also, of course, with Italian citizenship applications. And this is Avvocato Giulia Crescini. Giulia, would you like to introduce yourself?
Hi, everybody. I am a lawyer in Rome, and I help people in Italy or abroad in order to obtain Italian citizenship or residence permission or visa.
Wonderful. Okay, that was very fast. We have been very fast. Let's dive into the core of this video. Today we will discuss a very specific rule, which is one of the rules that would allow you to avail yourself of the famous, very famous Article 3 bis of the this new Article 3 bis of the law of citizenship, Italian citizenship, which was, as we all know, was enacted, so was introduced in 2025, March 2025. So this article was like very bad for all the children and nieces and nephews of Italians living abroad who were not in Italy when they were born, and so on and so forth. So there are specific rules that would just cut off the possibility for you, if you want to become Italian and you have never been in Italy and your parents or grandparents never lived in Italy, it is very hard for you now to become Italian citizen. But we have some exceptions, apart from the fact that, of course, you can turn to a court, and this is why we are also talking to Giulia in this video series. So now, today, we are talking specifically to letter D of Article 3 bis, which is an exception to the Article 3 bis cut-off rule. So if you were born abroad and you have another citizenship, which is like 90% of the cases, you are born abroad, you have another citizenship, then you fall within the scope of Article 3 bis. So you are not born Italian, even though you are born from an Italian person, from Italian. You're not Italian automatically. So let's see what are the exceptions. One of these exceptions are set forth by letter D, is set forth by letter D. So you would be considered Italian if a parent, I'm reading it, or adoptive parent has resided in Italy for at least 2 consecutive years subsequent to the acquisition of Italian citizenship and prior to your date of birth or adoption. Okay, so there are different specific things to consider, because this very short sentence includes so many things to take into account. So Giulia, would you like to break down this specific provision for us?
Yes, of course. So this provision is one of the exemption to the rule that says that if you're born abroad, you cannot become Italian citizen. In this case, if you are born abroad from a person that is both Italian and has also another nationality, you have an opportunity to become Italian. We are used to call this provision super Italian person and super Italian father or mother, because the rule says that if even if you are born abroad, you could become a nationality if the rule of the 2 years is respected.
Yeah, there's a factor.
Specifically, your father or your mother needs to be Italian and needs to be Italian 2 years before you born and 2 years after they obtain Italian citizenship. Of course, this provision needs to be read in from different point of view, depending on the way in which you obtain your citizenship. Because another very important things regarding this provision is the fact that it's not important the way in which you obtain your citizenship. So you could be Italian by blood, so because you born in Italy, for example, or abroad from a mother or father that were Italian. But also if you obtain Italian citizenship by marriage, by naturalization, or
Yeah,
because you born in Italy and you obtain Italian citizenship when you were 18 years old. So of course, if you born in Italy, I am a mother or a father. I have a mother and I born in Italy. And after 2 years, so when I was 2 years, 3 years, 5 years, my parents decide that I need to move in another country. I fulfilled the requirement of 2 years of Italian citizenship before the born of my child, and also the 2 years after my way of recognition of citizenship. But of course, this provision needs to be read also for people that become Italian after naturalization, so 10 years of residency or marriage. In this case, it's important that the person that became Italian needs to become Italian 2 years before giving birth or before having a child and remain in Italy 2 years after. From this point of view, it's easier to understand why we call this way of transmission of Italian citizenship the super Italian pathways, because in order to transmit Italian citizenship, I need to give evidence to Italian government, Italian states, that after the recognition of Italian citizenship, I remain in Italy at least 2 years before giving birth.
Yeah, that was quite clear. So this super Italian pathway. So this is one of the things that we said in the last months to clients turning to us and asking us, about a legal opinion about this requirement. And we tell them, look, if you become Italian and you reside in Italy, please try and stay for at least 2 years. Because then, and we use something like that in Italian. I said like you become another level, like a different level of Italian, because then all of your children can become Italian because you stayed legally for 2 years, so officially registered in Italy for 2 years, consecutive years, after you have become Italian. So you acquire this superpower, and then you can give birth anywhere in the world, and all your children will become Italian just because, for example, you stayed one more year. Because maybe, this happens a lot with foreigners who, for example, come here and they want to stay here and they become Italian because they stay, I don't know, for 10 years, and or they get married to an Italian, and I don't know, they get divorced, and that they want to have a new life. And just after you have become Italian, if you stay 2 more years, you officially residing 2 more years, then you're quite a superpower. So think about it before moving abroad, because then it could be, much more difficult for your children to become Italian if they are born abroad, of course. So that's a provision which is uh, it's easier to prove this requirement compared to letter C, which we have seen in a previous video of the series. You can find on the YouTube channel under the playlist, the citizenship application, Italian citizenship. And because, of course, you just need to prove that you are Italian and you stayed in Italy for 2 consecutive years after you have become Italian, and of course that your children were born after these 2 years. Of course, this applies also to people who became citizen by birth, of course. So if you were born Italian after 2 consecutive years of your stay in Italy, so let's say that you moved when you were 3 years old. So your parents, they were staying in Italy and you were born, and so you were three years old. It happened to us. That a client would, just, oh, I was so little when we moved. And sometimes they moved when they were 1 year old. So they don't fulfill the 2 consecutive years requirement. Yeah, so you don't have this letter D. But most of the time, I mean, if you are born in Italy, most of the time, at least a couple of years, you stay here and then you move abroad. So, and in this case, you could avail yourself, for example, of letter C, because, for example, your mother is only Italian. So you want to transmit to your daughter, which is the niece of your mother, you would like to transmit Italian citizenship through letter C, but then you think, okay, but letter D is easier because I don't have to prove that me or my mother, I don't know, one of the descendants are only Italian.
Exactly.
I can prove that I stayed in Italy after I became Italian. I stayed in Italy for 2 consecutive years, and so I became super Italian. And so I can transmit Italian citizenship. So from a strategic point of view, it is useful to think about the different strategies you can, of course, avail yourself of. So of course, reviewing my questions. Yeah, that's a very logical questions. I mean, yeah. Let's say that a parent, so that you as a parent stayed in Italy for 2 years, but the municipality somehow didn't register you, or I don't know, it was a mistake on the registration, so the time frame was not 2 years, like 1 year and 2 months. I don't know. There was a mistake by the municipality officer. Okay, but you know that you actually stayed the 2 consecutive years. What can you do in this case?
Okay, very good question. It happens not all the time, but almost all the time, that there could be some problems in the registering of your residence, of your address, and there is no specific records of the 2 consecutive years. This is a problem, of course, because for the municipality and for the Ministry of Interior that needs to declare your or the Italian citizenship of your daughter or son, will go directly to check if there is the records on the municipality that show that your residence is registered for at least 2 consecutive years. Is also true that in Italy there is, in this moment, a number of decisions of the tribunal all around the national territory that says that residenza, so 2 years of residency, is not the registration in the municipality record, but is the but it can be sure the 2 years of residency. It could be sure by collecting all the evidence that prove that you stay for at least these 2 consecutive years in Italy. So, for example, if you have whole, for example, in these 2 years, because your records is shows that there is a period in which you were not residents, or if you had the problems because they cancelled, or you delayed your the starting
Yeah.
of registration, you can prove and you can show to the Ministry of Interior or to the municipality that you were in Italy also this specific period of time, collecting and showing all the evidence that could be rent, job contract, rent, or, for example, the
Can you
fact that you pay taxes, or the
withdraw money from the ATM?
Yes, it could be, but I mean, there
I'm
is
thinking about all this.
no. It's also possible that another
Yeah,
person,
yeah, yeah.
a part
I'm
of
thinking
you,
about all the possibilities.
withdraw
Yeah,
money. But for example, if you went to the hospital, if you
yeah,
had a child, if you had a son or a daughter,
yeah.
and so on. Um, of
Okay.
course, there is also another way to show that your residence was continuative in Italy for these 2 years. So one way is collect all this evidence and ask the municipality to recognize the Italian citizenship of your daughter or of your son on the basis of the fact that you were in Italy, even if your residence was not registered. Another way is to go directly to the civil tribunal, asking the judge to record your residence even if a lot of time passed. This is something that we are used to do, and the judge simply ordered the municipality to record your residence in Italy. In this way, you can show the municipality of the or the interior minister that you were residents for at least 2 consecutive years.
This is quite clear. So another question that I would ask if I were an applicant, I would say, let's say that I stayed 3 months abroad because I don't know, I had to work abroad. Would this constitute a break of the time frame? There would be a hole in the time frame if I just stayed 3 months abroad to work for my company.
No, of course, this is not absolutely a break of the presence of a person in Italy. The importance, of course, is that in particular, if the record of your residence they have no break, of course, there is no problem. In case you decide to work abroad, you should maybe and stay maybe more than 3 months, for example, 6 or 7 months, you have to pay a lot of attention that there is no break in your residence records. Otherwise, it will be very, very difficult to show that you remain in Italy while you were in another country working.
Yeah.
What is important that you can show the link between you and Italian territory.
Yeah, okay. Quite clear. I'm just reviewing the questions, okay? Get back to you in a second. Yeah, okay. So the last questions that I have regarding this proof of residency. Let's say that there was a flood or fire, so the records were destroyed, which might happen. I mean, or they get lost, for example, because the municipal officers, I don't know, were angry that they threw everything away. So let's say you can find the records.
Yes, I mean, of course, if I am asking my citizenship for my son or for my daughter after I became Italian, like in 2000 or in 90s, this should be not a problem because all the records are like digital and so on. But the problem is if I'm asking Italian citizenship for my son or for my daughter, because when I was a child, maybe in the 60s or in the 50s,
Yeah.
I born in Italy, and I remain in Italy for 2 or 3 years, and then my parents decided to move abroad. So I'm trying to recover my Italian citizenship in order to transmit Italian citizenship to my daughter. In this way, it could be possible that these records are not present anymore. Again, I think that what we can do in this case is to go directly to the civil tribunal to ask the judge to declare the residence of this person in Italy for at least 2 years. For example, if I was 5 years old, I could ask the judge, I could provide the judge, for example, evidences regarding the enrollment to school or vaccination or something like that. If I was 10 years old, maybe the first identity card or something like that. Again, collecting evidence is also possible to ask the judge to restore the residency in Italy.
Absolutely. I mean, you could ask for school records,
Yes, of
for example,
course.
or elementary school, yeah, high school, whatever. So you can collect evidence in other ways which are not municipal records, which are not very trustworthy. Mostly when you have to collect evidence from the 50s, 60s, I don't know, even 40s. So yeah, so maybe they don't have the records anymore. They're not nowhere to be found. Or for example, if you were living in Rome, which is a mess, a real mess, Rome, from a registry point of view. So
Yes.
I don't know whether there are, because this is about, quite straightforward, this letter D, to me, at least if we don't consider other cases, like cases of minors living with people acquiring citizenship, which is different, something completely different, which is a very specific thing. Maybe it's the hardest provision that you can think of when it comes to this new law or this new provisions of this law, because they are interconnected. So several rules interconnected, and they just made a mess. The legislator made a mess, and then there were other provisions, circular letters from the ministry explaining this mess, and I think making other mess. Anyway, but maybe we'll talk about this in another video, a very specific video. So, Julia, do you think there is anything to add to what we have said?
No, just to remember that this provision could be very useful because there is no importance the way in which I obtain the Italian citizenship, and I could transmit Italian citizenship to son or daughter born abroad, even if I have another citizenship.
So, in case you have another nationality, so you can avail yourself of letter C of the Article 3 bis, and you have resided in Italy for at least 2 consecutive years after the moment when you acquired the Italian citizenship, which could be acquired anyhow. So naturalization, marriage, by birth, doesn't matter. Then you have this superpower, and then you can give the Italian citizenship to your children. That's a very important provision. So, Julia, I think we have been comprehensive, and we have talked about this letter D, and I'll see you in the next video. We will be talking about how to give Italian citizenship to minors, and we will see this Article 4, paragraph 1 bis. Is that right? Okay. Okay, so I'll see you again soon.
Thank you. Thank you. Bye-bye.
Bye, everybody. Bye, bye, bye.